This is Bloomberg Law with June Grasso from Bloomberg Radio.
Will the FTC try to stop the largest packaged food deal in years? Mars, known for its candy like M&M's, Milky Way, Skittles, Twix, and on, wants to buy Cheez-It maker Kellanova for nearly $36 billion. But will FTC Chair Leah Nylen's views about a chocolate oligopoly lead to a challenge to the deal? Joining me is Bloomberg antitrust reporter Leah Nylen. Leah, tell us how Leah Nylen had a problem with the chocolate oligopoly about a decade ago.
Before she became FTC chair, Nylen worked for an advocacy group that focuses on antitrust, open markets, and she did a lot of research and writing sort of about consolidation within various industries, and one of those was food. So about 10 years ago, she wrote a story about how there had been a significant consolidation within the candy industry, particularly chocolate candies, and how today there are only about 3 major chocolate companies. That's Nestle, Mars, and Hershey's. You have a couple other ones like Ferrero Rocher, which is the Italian company, but those are the big 3. So even though when you go to the grocery store, you see like what looks like, dozens of different brands, really most of those are owned by one of these 3 companies. And so she was lamenting a little bit how when there is this kind of consolidation, there ends up being a little bit less innovation in marketing.
See, now, I would wish there was less innovation in candy so that I would not be so tempted. I never noticed that there was a lack of diversity in candy. So tell us about this proposed or possible Mars deal.
Yeah, so Mars, which is primarily a candy company, is looking at buying Kellanova. Kellanova is a company that was spun out of Kellogg. So Kellogg, the cereal company, decided to split up its business in between Kellogg, the traditional cereal, and like everything else it did. And so Kellanova is sort of the everything else. So it has Pop-Tarts, it has Cheez-It, it has Nutri-Grain bars, it has all of these other sort of like snack food and frozen items in packaged food. And so Mars would like to buy it because, as I said, primarily it is a candy company, but it would like to sort of get a little bit more into snack food. So they are looking at doing a $36 billion deal, and it's really going to put Mars into one of the top packaged food companies in the world. So right now, the top ones are Unilever, PepsiCo, and Nestle, and this would make Mars the number 4, right behind those 3. So the FTC is going to take a look at the deal because there's a lot of interest in food right now, particularly with all the inflation that's been going on. There's been some suggestions that the reason that food prices haven't come down as much is because there is so much consolidation in the industry that a lot of the food companies can sort of keep their prices high in a way that they would otherwise not be able to if there was more competition.
They do compete in snack bars. Is the analysis going to depend on how they compete in snack bars, or is it going to focus on their becoming then the 4th largest packaged food dealer? I mean, it really doesn't seem like there's a lot of overlap in what Mars and Kellanova do.
Yeah, the biggest overlap is, as you said, in snack bars. So one of them owns Nutri-Grain and the other owns Nature's Bakery. And if you've ever had those items, they're very similar. They have the fruit in the middle and then sort of the grains on the outside. One of them also owns Kind bars, all those like nut and chocolate ones. And the other owns RX bars, which they often have like fruit and nuts mixed together into sort of a bar. But these are all sort of like the slightly healthier snacks and or sort of meal replacement type things that you might, grab when you're hungry. And so the FTC is definitely going to take a look at that. And, the traditional way that this would be resolved is that they would try and sell off one of these brands. They would keep one and they would sell off the other. This FTC has been a lot more reluctant to accept that kind of a deal. I mean, I am here in Portland because of the Kroger-Albertsons deal, and that's exactly why they're challenging it. Kroger and Albertsons are saying, we'll sell us some supermarkets, everything will be fine. And the FTC is like, we're not really sure. So that may be a little bit harder in this case.
How long does the FTC have before they have to make a decision in the Mars case?
Yeah, so Mars and Kellanova just announced this deal a couple weeks ago. They will file their initial paperwork pretty soon. And then the FTC will have 30 days to decide if it wants to do an in-depth review that we call a second request. A lot of the people I spoke to said they believe the FTC is definitely going to do a second request here. Once it goes into the second request phase, that can take several months or maybe even up to a year for them to sort of make a decision about what they're going to do with the deal.
So speaking of Kroger-Albertsons, I understand that the surging grocery prices played a big part in the opening statements at the trial.
Yeah, this is a merger between what the U.S. calls the two largest traditional grocery stores, Kroger and Albertsons. And, they're sort of one-stop shop places where you go and you can get sort of all of the food you might need for a week. And they have alleged that both Kroger and Albertsons spend a lot of time thinking about how the other one prices, particularly on what they consider to be consumer staples, which are things like milk, eggs, bananas, things along those lines that Americans purchase a lot, probably even weekly. So we have heard a lot about egg pricing in particular. There's been a lot of up and down in egg pricing since the pandemic, in part because there have been a couple like bird flu outbreaks here in the U.S., but there has been some testimony that Albertsons and Kroger look to each other very significantly on how to price their eggs. They do weekly reports on what the other one is charging in the market.
Really?
And they oftentimes, adjust their pricing based on what either, Kroger or Albertsons is charging. The companies have argued that they don't compete with each other as much as the FTC claims, that really their biggest competitor is Walmart. Walmart obviously is one of the biggest food sellers in the United States, but, we've seen at this point dozens of documents in which Kroger and Albertsons refer to each other as either their primary competitor or their biggest competitor. And while they do look at Walmart for some pricing, it's pretty clear that they are very, very focused on the other traditional supermarkets.
There was testimony at the trial about the company that would buy almost 600 of the divested stores from Kroger and Albertsons, C&S Grocery Wholesale.
So in order to get the deal through, the companies knew that they competed directly in a lot of areas. And so they offered to sell 579 stores to a company called C&S Grocery Wholesalers. So C&S is primarily a grocery wholesaler. That means that they buy the products from the consumer packaged goods or from the farmers. They keep them in the warehouse, and then when the supermarket needs to stock its shelves, it orders from them, and they send a truck to the supermarket with all of the goods. So a lot of the bigger supermarkets like Kroger and Albertsons sort of do this warehousing and distribution themselves, but smaller grocery chains use wholesalers like C&S. So as I said, C&S is primarily a wholesaler. It does operate 23 grocery stores in upstate New York and Wisconsin. So buying 579 stores would be like quite a significant change for this company. And they argue that they are really excited about this possibility, that they would really like to sort of diversify their company beyond just being a wholesaler, and that it sort of makes sense for them, since they are so involved in grocery, to pick up grocery retailing. But the FTC argues that this is putting a lot of the risk onto consumers, because if this divestiture package were to fail, all of a sudden there's not going to be as much grocery competition in a lot of places around the country. Consumers would only have the option of the combined Kroger and Albertsons.
And C&S doesn't have a great record of keeping supermarkets that they buy.
Yes. So historically, as I mentioned, C&S has played a little bit in the retail business, but what they would do is they would buy a couple grocery stores, primarily from other companies that were already their customers, and then they would keep them for a while and then sort of sell them off or sell them back to somebody else. So there was a period in time in the early to mid-2000s when they had a couple hundred stores, but by 2012, they had completely exited the retail grocery industry. So for a long time, they operated no grocery stores whatsoever. In about 2021, they sort of decided to get back into the retail business, and that's when they started acquiring a couple more stores. And as I said, they now operate just 23 of them, only in these two places in the country. Even though they are a big distributor, they also don't have any even of their distribution business in some areas of the country where they would be buying stores. So they don't do a lot of work right now in Southern California, where they would be buying something like 90-something stores. And they don't do any real business in Colorado right now, where, again, they would be buying 90-something stores and taking over sort of the Safeway brand in Colorado only.
And this hearing is just to allow a judge to decide whether or not to issue a preliminary injunction against the deal.
Yeah, so technically this is a preliminary injunction hearing. The judge is going to decide whether to block the deal from going through while the FTC moves forward with the proceeding in its in-house court. The companies have already said that if the judge blocks the deal here, they're probably going to abandon because the deal has already now been pending for 2 years and they can't really keep waiting given all of the financing and things that are up in the air with this merger. So if she ends up ruling against them, they'll abandon the deal and sort of move forward with a new strategy.
Do you know what other kinds of witnesses are going to testify?
Yeah, we are almost done with the FTC's case. So we've heard from a lot of Kroger-Albertsons sort of mid-level managers in the various regions. We've heard actually a lot from various union officials because one of the interesting things about this case is the FTC has argued that it would reduce competition for unionized labor because both Kroger and Albertsons have large unionized workforces, all of the people who work in the stores. And they argue that eliminating the competition between Kroger and Albertsons would lead to lower wages for their workers. The FTC is expected to finish up probably tomorrow morning, and then we're going to hear from the Kroger CEO and the Albertsons CEO, who are going to talk a lot about, why they want this deal to move forward.
It's very interesting because you have two of the issues in the presidential campaign, inflation and union jobs.
The Harris campaign has already said that they oppose this merger, so we will see what happens.
Thanks so much, Leah. That's Bloomberg antitrust reporter Leah Nylen. Coming up next on the Bloomberg Law Show, Texas is making a long-shot bid to become a business law center with a little help from Elon Musk. I'm June Grasso, and you're listening to Bloomberg. There's no doubt that in the tiny state of Delaware is the world's preeminent business court, the Delaware Court of Chancery. Delaware is the legal address for nearly 300,000 businesses like GM, Walmart, and Goldman Sachs. And in a 2-century-old commercial court sits one chancellor, 6 vice chancellors, and 3 magistrates considered the best judges in the business of judging business cases. Now into this picture comes an unlikely challenge from Texas. It's launching its own version of a business court without a designated courthouse or even designated courtrooms. Joining me is Bloomberg Texas legal reporter Madlin Mekelburg, who's investigated Texas's bid to become a business court hub. Madlin, start by telling us about the Delaware Chancery Court.
I think there's no question that the Chancery Court is the preeminent business court. And although it's a small state and a small state court, it has global implications because so many businesses are incorporated in Delaware and have it set up so that litigation like shareholder actions go through the Chancery Court. There are decades and decades of precedent out of that court on really crucial business law cases. And those decisions, given the stature of this court, those decisions have impact felt across the whole country. I was speaking to a law professor at the University of Texas for this story, and he told me if you're taking corporate law classes anywhere in the country, you're learning about Delaware law, whether you plan to practice in that court or not, because of the significance of the decisions that are coming out of the Chancery Court there.
And also, the court's 10 officials, the judges are experts in business law.
That's exactly right. The idea is that these are people who come from really high-profile corporate litigation practices already. They have a ton of experience and knowledge in this space, and they're appointed to serve 12-year terms in the court. And so they're really steeped in the current issues of the day, and they have a reputation of being some of the top legal minds in the country.
Now, Texas has made a concerted effort to attract businesses. Abbott is promoting the Texas Miracle. What is that?
That's a great question. Definitely, Texas has been working for a long time now to cement its reputation as a really business-friendly state. I think the number changes, but there's something like 50 Fortune 500 companies that are headquartered here. But what Texas and Governor Abbott is talking about there is this idea that businesses can come to Texas and experience lower taxes. They can experience a really robust workforce. There's tons of physical space. Texas is a ginormous state, so if you're looking for somewhere to set up a business, set up an operation, chances are we've got the land for you here. I think we're also have a reputation of having business-friendly lawmakers who really are attuned to the issues of businesses and have shown a willingness to listen to what they're looking for when it comes to crafting regulations for the state. And so Abbott has been looking for ways to kind of expand on this reputation, add more to the arsenal of things that Texas uses when it's trying to recruit companies to come to the states. And that's why we're chatting today. The latest development in that effort is the establishment of dedicated business courts here in Texas.
Are they trying to become the next Delaware? Are they trying to directly compete with Delaware?
So not necessarily. Texas is not the first state to attempt to create business courts. There's maybe 22 other states that have some form or fashion of specialty courts. And so on paper, the reason to pursue these courts is to separate business cases from the regular docket, because right now, a really complicated contract dispute or shareholder lawsuit is going to be decided alongside personal injury cases and family law disputes in state courts across Texas. And so what they're trying to do here is to create a similar system to Delaware, where you have specialty judges who have experience in business and corporate litigation who can help speed resolution of some of these cases that can tend to get stuck in the dockets. But I think, for reasons I'm sure we're going to talk about more, I think Texas's reputation just as a business-friendly state, some of our more famous business residents here, it kind of gives Texas a bigger opportunity to go against Delaware. And so whether they're trying to or not, the way that the situation is playing out right now is that everyone's looking at Texas as maybe not a direct challenger to Delaware, but certainly an alternative to Delaware that could eventually kind of develop a similar reputation as a place to bring these kinds of disputes.
I think you were referencing, perhaps, Elon Musk, who I'm sure feels he's had a terrible time in the Delaware Chancery Court and has been promoting Texas.
That's exactly right. Elon Musk decided to shift the incorporation of Tesla and SpaceX to Texas. I think the final straw for him was when a judge in Delaware's Chancery Court struck down his massive $56 billion pay package that was approved by Tesla shareholders. And he said, guys, I'm going to Texas. He has a long history here of having his physical headquarters and office spaces here. But by moving the legal home of these companies here, he's kind of ensuring that these future spats involving shareholders and specifics of the business are going to be resolved in courts in Texas. Now, he hasn't said that he was coming here to specifically experience the business courts that we're setting up, but it's just the timing of it. He announced his decisions a few months ago, and the Texas business courts just started operating this past weekend. So whether he wants to or not, I think he's going to be one of the early and most high-profile cases that those courts see.
So Chevron moved from California after 145 years. You know, it was having problems with California's environmental policies and regulations. Are a lot of the corporations moving there trying to escape from states that are not as business friendly and going to Texas, which seems to have open arms out for business?
I think that's certainly a factor for a lot of businesses that decide to come here. It's hard to imagine that being the only factor that they would make that decision based on, but certainly I think that's part of the idea of this Texas miracle, and part of the arsenal of tools that Abbott uses to recruit businesses is this idea that, yes, we are business friendly, we have business friendly judges here, and we have regulations that are friendly to business, kind of all of the above. And I think that we're going to see a similar dynamic play out with these business courts, where the judges in Texas are appointed by Abbott. I think a lot of people assume, probably correctly, that the judges share his similar ideology when it comes to business and when it comes to applying law in a maybe more conservative fashion. And so I think these courts will be an extension of what we've seen when it comes to presenting Texas as an alternative to some of these areas like California that are known for their more liberal policies, let's say.
Governor Abbott said, the judges have a litany of experience in streamlining resolutions of business disputes. Do they? I mean, it doesn't seem like you can really compare the judges in Texas to the judges in Delaware.
Definitely not. I mean, Delaware's judges, this court has decades and decades of precedent. They serve for 12-year terms. This business court is, as we're speaking today, about 2 to 3 days old. So I think it really remains to be seen how they're going to handle these cases. The judges he appoints were required to have 10 years of experience in either complex corporate litigation or as a judge in Texas. So they definitely do have experience in this space, but none of them, as far as I'm aware, have experience as a judge in this kind of setting, as handling these specific disputes in a business court setting. So I think it's going to be one of the things people are watching for is how quickly they can take a case from filing to resolution.
And also, Texas courts, in a lot of instances, are going to have to follow Delaware law because that's the only law on some of these issues.
That's right. I mean, these are state courts, and so they're going to be referring to Texas corporate law in a lot of fashions. And so we do have precedent in terms of how corporate law has been applied in cases in the past, just in a regular state courtroom. But a lot of those applications we've seen previously are based on Delaware case law. That was kind of what I was saying earlier, this idea that the power of Delaware Chancery Court is these huge decisions that have significance that are being applied in other cases. And I don't think that's an exception here. I think what's different is perhaps how these judges might apply or interpret those statutes when it comes to specific cases. So I think that's another thing that remains to be seen is how far they'll be willing to deviate from what's kind of standard and expected in this space.
Madlin, as you pointed out in your story, the terms are only for 2 years, the judges' terms. So that means that they may be leaving in the middle of a case. I mean, we all know how long legal cases take.
Yes, and basically all the lawyers I spoke to for this story said that would be amazing to have a case that wraps up in 2 years or less. But I think that's another thing that is, again, a lot of the conversation right now is a wait and see. It's hard to really understand how these courts are going to work until we see them start taking cases and start getting to that period where there might be turnover. Because the way that they've been set up under state law is that the judges can be reappointed to terms following this. So it's possible that the judges we have now, their 2 years are up, Abbott renews them, asks them to come back for 2 more years. But we just really don't know how it's going to work at this point, if that's something that's going to be understood to come for these judges or what. But as it stands right now, 2 years is definitely a short term. I think I mentioned Delaware judges serve for 12 years, and so that's one of the big differences between our system here and what they have in the Chancery Court.
So they've been planning for more than a year. Are the courts located in one central building like in Delaware?
No, that's another thing. Texas is a huge state, and there technically are, I believe, 11 divisions that they hope someday will exist for the business court. But what they've decided to do is start small. So they're opening 5 divisions over the biggest cities in the state, and that's Austin, Dallas, Fort Worth, Houston, and San Antonio. And that was one of the things we've been watching as this September 1st deadline for the courts to start operating has snuck up is, where are these courts going to be located? How are they going to handle filings? Is it going to be electronic? A lot of those questions were unanswered. And even up until a few weeks before the courts were supposed to open, we were told they were still looking for leases for courtrooms within those different divisions. But they decided to kind of abandon that effort for now to find permanent physical space. And judges will have offices within their division, but when they need a courtroom, the plan right now is to use available existing infrastructure from other state courts.
What's the time frame for determining whether or not this is a success? I mean, it feels like they're opening without even having everything in place.
It's brand new. I think it's going to be a few years before we really understand whether this was a successful experiment. I think an early first test is going to be, can they take a case from start to finish? I think that sounds like a really low bar, but creating a completely new court system almost from scratch is a huge undertaking. The court themselves kind of told us that just because September 1st came on the calendar doesn't mean their preparations are finished. There's still a lot of work to do. They're still hiring staff. So it's not like what we're seeing today is what the courts are going to be looking like 1 year from now. They're still building up their internal infrastructure. So I think it's going to take at least 2 years for a full judge's term to really understand kind of what the potential is for these courts. And then I think another big question is going to be whether Texas leaders see this as a worthwhile investment to continue putting money and resources towards growing these courts and supporting the existing courts they have.
This is certainly an ambitious project that Texas is taking on, and I know you'll keep following and let us know how it's going. Thanks so much, Madlin. That's Madlin Mekelburg, Bloomberg Texas legal reporter. Coming up next on the Bloomberg Law Show, it was a busy summer for the Supreme Court as the justices had to handle what could be a record number of summer emergency applications. I'm June Grasso, and you're listening to Bloomberg. In just about a month, the Supreme Court justices will begin their new term on the first Monday in October. They left the Supreme Court for their summer vacation on July 1st, but the summer has been relatively busy for them. They've decided 11 emergency applications, and they're on track to perhaps triple that before the new term starts. Why all these summer emergency applications? Here to explain is Bloomberg Law Supreme Court reporter Lydia Wheeler. We used to hear about the emergency docket, the shadow docket, in reference to death penalty cases. What kinds of cases are we seeing now?
You're completely right. So the emergency docket, or what legal scholars are calling the shadow docket, was once primarily used for these last-minute stay requests in death penalty cases, as you mentioned. Basically death row inmates were coming to the court and saying, hey, stop my execution while I fight for a new sentence in court. Now, the requests cover a much broader scope of issues. I'm talking about now we're seeing often hot-button issues like abortion, voting rights, even the power of federal regulators, issues that are really dividing the nation politically. Those are what's coming to the court on this emergency docket.
Explain how the shadow docket is different from the merits docket. In other words, the truncated period for filing briefs, et cetera.
Right. So the shadow docket is the name that legal scholars use when referring to the emergency docket. And they call it that because the court decides these requests through a truncated process without full briefing or oral argument. The decisions are orders that are usually only a sentence long, and we never know kind of when they're going to come out. It's not like on a specific decision day. So there's that. Right now, they're happening over the summer when the court isn't even in its normal session. And unless there's a notable concurrence or a dissent, there's usually very little insight into the court's reasoning for why they're either blocking something or letting something take effect. We don't know what the vote count is usually, which justices decided, for which side. So there's very little information, which is why, one legal scholar kind of coined the name shadow docket and why that term has kind of taken off.
So now tell us about some of the decisions on the shadow docket that the court has made this summer.
Right. So the court recently rejected the Biden administration's request to reinstate the Education Department's new rules that protect transgender students from discrimination in school nationwide. That was actually a rare one where we saw a partial dissent from 4 justices. Actually, conservative Justice Neil Gorsuch joined the liberals, which is Justice Sotomayor, Justice Kagan, and Justice Jackson, in saying that they would have let those rules take effect. Last week, we also saw the justices allow Arizona to enforce part of a state election law that will require voters to show proof of citizenship to vote. And it's unclear if that will, again, be blocked or if that will be a requirement likely during the 2024 presidential election.
Lydia, we're watching to see whether the court is going to hand down decision or when the court is going to hand down decisions in several different cases. Tell us the ones that we're waiting for.
They still have more than a dozen applications still pending. I think at this point we're up to 15 or 16 now. Legal scholars told me they're really on track to triple the number of cases that they decide on the shadow docket this summer. I'm personally waiting for one right now that has to do with family planning funding in Oklahoma. These are dollars that HHS stripped from the state of Oklahoma because the state wouldn't agree to force its healthcare providers to offer abortion referrals. They said that that is a violation of their new abortion ban, a near total abortion ban that took effect after the Supreme Court 2 terms ago in 2022 overturned the constitutional right to abortion and left that up to the state to decide. Georgetown law professor Steve Vladeck, he has been tracking these requests, and he actually shared his data with us. He said that the court is on track to blow previous summers out of the water when it comes to the number of emergency actions that it's taking. He said that even includes the first summer of the COVID-19 pandemic, when there were actual true emergencies that the court was being asked to act on.
You can understand why during COVID there was an uptick in these applications, but why so many more emergency applications these days?
Right. So this is actually something that the justices themselves have spoken to. And Justice Elena Kagan is really someone who kind of gave us the first understanding of why this is happening. She said that, in granting a number of these emergency requests that were brought to the court during the Trump administration years ago, she said that the court really encouraged people to kind of keep bringing these kinds of petitions for emergency relief. And so the court basically kind of sent the signal like, hey, we're now open to these kind of requests. And now what we're seeing is we're really seeing a lot of these requests come from Republican-led states and also industry groups that are looking to block Biden administration policies. Now, the concern here is that the court, in acting so many times on these requests, that they're changing kind of what's considered a true emergency. And legal scholars that I spoke to actually said that further undermines the court's credibility. And, we know that the court right now has very low public approval ratings due to their ongoing ethics issues and controversies, and also the spat of controversial decisions that the court keeps releasing that are really split along ideological lines. I'm thinking about last term, the court's decision on presidential immunity, and also their decision to overturn the federal ban on bump stocks, which are those devices that allow guns to fire like a machine gun.
Are the justices complaining because they have to work during the summer more now, or are they complaining for other reasons?
They actually, several of them have come out in public appearances and lamented that oh my gosh, this is way busier. Justice Sotomayor recently said, I'm tired. We're not used to working around the clock like this, and the number of requests that they're getting is a lot. Justice Kavanaugh also said that it's challenging, because the number of emergency applications that they're getting takes time away from the court's merits docket. And now the merits docket is actually what they refer to as the normal process for the court, hearing a case and deciding it. That happens during the course of their normal term, which begins the first Monday in October and traditionally runs until the end of June. Now, they can go a little longer than that. We saw that unusually happen this summer where they ran into the first day of July. But usually they like to wrap everything up at the end of June, and then they get a couple months break with the occasional emergency request. But now it seems like there's this flurry of activity. Justice Clarence Thomas also commented on this. He said that the emergency process really short-circuits the court's normal process for hearing disputes, and he said that it's not a, quote, thorough way of dealing with these issues. But Justice Kavanaugh and Justice Thomas really didn't offer any sort of solution. At least nothing publicly was said about what the court should be doing. As I mentioned, Justice Kagan was really the only one who came kind of closest to that when she said, hey, this phenomenon is kind of caused by us. We're granting these opinions, and we're sending the signal that we're open to this kind of decision making, and hey, send your stuff our way. So that seems to signal to me that one way that the court could kind of avoid doing this, which we saw them do in past terms, is to take cases that come in on the emergency docket and move them over to the merits docket. The court definitely has the power to do that.
Yes, Justice Kagan is definitely the most outspoken, or reveals the most of the justices, it seems. And also, she talked about, and, the Supreme Court has, during oral arguments, talked about how lower courts, it's a problem that they're issuing these nationwide injunctions, but no one has done anything about this. So she said that they have to intervene then.
Right. That's what she said. Sometimes, we have to step in because, as you mentioned, right, lower courts are, they'll get a dispute that comes to them. Instead of just blocking some sort of policy that impacts the party that's before them, these courts are taking it upon themselves to block a policy for the entire nation, to make it so that no one has to follow, the new policy or new rules that the Biden administration has put in place or an administration has put in place. This is not just a Republican tactic, I should say, that this has also been something that Democratic state attorneys general have also pursued, bringing these challenges against the administration and challenging those. So not necessarily just something that red states are doing, but also blue states have done in the past as well. But yeah, she said that, sometimes we have to step in, like there's no other choice.
Are they expecting, or are legal scholars expecting to see election cases on the shadow docket?
Yeah, that's definitely something that could come as we get closer to the election, to see more of these disputes. That's something we're expecting to see. I would expect over the next several weeks, maybe to see those coming to the court, and definitely, as they start the beginning of their term, it's going to be very busy, lots to watch out for. So yeah, I guess, stay tuned, because there's definitely more to come in the shadow docket. This isn't an area where they are slowing, the number of requests that are coming to them. They seem to be popping into my inbox, from the court's press office almost every day. So a lot of activity. And
it was interesting. You talked to a University of Virginia law professor who said that increasingly state attorneys and state solicitor generals are challenging federal laws in the courts.
They are, yeah. This is kind of a new tactic. I talked with legal scholars who said that state attorneys generals and solicitor generals, those are the attorneys that represent the states in their challenge before the Supreme Court, that they are really kind of acting like normal litigants now, more so than ever, and that they're bringing these big actions and challenging the administration, And what's interesting is I've done reporting in the past where kind of do a lot of venue shopping, a lot of forum shopping, where they seek out particular parties. They all kind of band together in multi-state litigation sometimes, and they seek out their preferred court to file these challenges in to try to get a judge that will most likely rule in their favor. And sometimes there'll be different groups of states. A couple states will file in like Oklahoma, and a couple states will file somewhere else. So it's like multiple challenges we often see with these cases of national importance and challenges to administration policies. You'll see a tactic is to kind of these states try their hands in different courts. And so you'll get competing rulings, and that often will make an issue more enticing for the Supreme Court when lower courts have ruled in different ways on the same issue, and you have a split in the decision, meaning one court rules one way and another court rules another way. It almost forces the Supreme Court to kind of be the decider and step in and settle it.
And that filing in two different jurisdictions and getting two different results is what Republican AGs did in attacking Joe Biden's latest push to reduce student loan bills. And just last week, the Supreme Court turned down the Biden administration's request to lift a pause that one of the federal appeals courts imposed on the program. So that's a perfect example of what you were saying, Lydia. Thanks so much. That's Bloomberg Law Supreme Court reporter Lydia Wheeler. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.